Continuamos también con la intervención especial para esta audiencia de Albie Sachs, magistrado de la Primera Corte Constitucional de Sudáfrica, postulado por el presidente Nelson Mandela y reconocido activista de derechos humanos. 6 minutos este video.
I am Robert George. I'm the McCormick Professor at the University.
My name is Albie Sachs. I was a judge on the Constitutional Court of South Africa in 2005 when we declared that the marriage law in South Africa was unconstitutional because it did not allow same-sex couples to get married. I will deal with 3 aspects. First of all, the basis of our decision on the merits of the case, why it was unconstitutional. Secondly, and primarily with the remedy that we adopted. And finally, with the whole question of how our court approached the relationship between the sacred and the secular, that is, the religious and the secular dimensions of the issue. First, the marriage law in South Africa was based on the common law inherited from England and from the Netherlands, unwritten common law kept alive over centuries by the judges implanted in South Africa, which declared that marriage was the union for life between one man and one woman. That was the common law. It was also indirectly incorporated into the statute, the Marriage Act, which allowed for public celebration of marriages, in which the marriage vow was declared to be as follows: I, AB, take you, CD, to be my lawful husband stroke wife. And it was clear that the words husband or wife were gender specific and presupposed one man and one woman. And this effective exclusion of same-sex couples from being able to take the marriage vows and celebrate their marriages in public in the same way as heterosexual couples was challenged. The matter worked its way up through the courts and eventually reached the Constitutional Court. We decided relatively without difficulty that the exclusion of same-sex couples from the benefits that heterosexual couples could get from the marriage law, that is, from the rights and the responsibilities and the public recognition that heterosexual couples could get, was manifestly unconstitutional. It was not as though the same-sex couples were being expressly targeted for exclusion. The legal problem was they were rendered invisible. The law was under-inclusive. There was nothing wrong with the law allowing heterosexual couples to marry. It was not unconstitutional per se. It was unconstitutional because it was limited simply to heterosexual couples. And the problem was how to respond to the invisibility. And the court unanimously decided, 11 judges, that the indignity imposed upon same-sex couples by not allowing their love, their intimacy, their eagerness to establish a life partnership publicly recognized, to have the same legal family law support as heterosexual couples got, was a profound undermining of the dignity of same-sex couples. And any suggestion that somehow a public recognition of their intimacy, love and affection and mutual responsibilities would undermine family law was a misconception about the nature of family law, that should be inclusive rather than exclusive. The question then was what to do about it. And this is where the issue of the remedy cropped up. The court, again, was unanimous in opposing the notion of separate but equal. Separate but equal in the South African history, as in American history, was used to exclude people of colour from receiving the benefits that white people had. It was never equal in practice, and it presupposed something odd, something different, something that almost contaminatory, something necessarily almost toxic in allowing people of different colours to have the same rights enjoyed in the same way. And we felt the same with regard to same-sex marriages. Separate but equal would not be an appropriate remedy. In other words, simply to allow same-sex couples to regulate their legal relationships in terms of tenancy, in terms of visiting rights, in terms even of parental rights, without embodying the cluster of rights in the concept of marriage, probably recognized as such, would not be appropriate. The M word, the word marriage, became central to our debates. And we said, the court said unanimously, it would be unconstitutional to deny same-sex couples the right to marry. The issue then was, how do you achieve equality with heterosexual couples? Do you equalize up or equalize down? Is it equality of the vineyard or equality of the graveyard? We could achieve equality of the graveyard by saying, well, if same-sex couples cannot marry, then heterosexual couples cannot marry, except in their faith communities. And we could have a civil union, a solemnly organized civil union for same-sex and heterosexual couples. And logically, that would be maybe a perfect solution. But the results in practice, in real lived life, would be equally obnoxious, both to heterosexual couples and same-sex couples. We indicated in our judgment that there ought to be equalizing up, equalizing of the vineyard, and not equality of the graveyard. Then, technically, how should we proceed? And here the court divided. One of our judges, Justice Kate O'Regan, said that the principle was very clear and the remedy could be found very simply by the court inserting the word after IAB, take UCD to be my lawful husband / wife, inserting the word spouse. Spouse is a gender-neutral word, and that would be the end of the matter. The court would have declared the principle, and from the very next day, same-sex couples would be entitled to use all the machinery of the Marriage Act to get their marriages registered. 10 of us, however, and I wrote for the 10 in this respect, felt that Parliament should be included in the project of establishing full legitimacy and public acknowledgement and acceptance of same-sex marriages. And the remedy that the majority of the court proceeded to announce was that the matter was referred to Parliament to make the necessary statutory changes in the way that it wanted, provided that the legislative result ended up granting same-sex couples the right to marry. The actual legal technology then was left to Parliament, and Parliament was given 1 year to do that. Now, this is something ordinarily within the jurisdiction of the Constitutional Court of South Africa. It provides for remedies under our Constitution of that kind all the time. The question was, what if Parliament did nothing within the 1 year? And here the court created something new for the specific occasion. The court said if Parliament does not pass the necessary legislation within 1 year, it would not be necessary for the parties to come back to the court in order to get a new remedy from the court. Automatically, the word or spouse would be included in the Marriage Act. And so from that day onwards, after the year had passed, same-sex couples would have the right to go to the public officials to get their marriages registered. As it turned out, the Parliament, very, very near the end of the 365-day period, voted by a huge majority in favour of an amendment to a law, or maybe a new law that was brought in, dealing with domestic partnerships being registered as civil unions for heterosexual couples. A special provision was inserted in that statute which allowed same-sex couples to register their domestic unions and to say, "I marry you." The M word, "I marry," was used in that statute. And from that day onwards, same-sex couples have been entitled to get married in South Africa. The last point I mentioned relates to how the court dealt with the question of the relationship between the secular public authorities, civil rights on the one hand, and the very strong religious convictions of a very large section of the South African community on the other. And here the point was made that there should be a coexistence rather than a competitive relationship between the two. That it would not be useful for people who upheld the right of same-sex couples to marry to condemn and denounce opponents of same-sex marriages as homophobes, as bigots. That was the worldview that other people had, that had to be respected. And the very same constitution that protected the rights of same-sex couples to marry protected the rights of faith communities who did not believe in same-sex marriages not to be compelled to perform and to celebrate such marriages. And the court went on to emphasize its respect for the importance of religious belief for millions and millions of South Africans, but to state that the religious doctrine and beliefs could not be used as a foundation for determining the civil rights, the basic human rights, the right to dignity of other South Africans.